CPL 120.2-2, quiz or question. When a criminal action has been commenced by filing an accusatory instrument which is sufficient on its face, and the defendant has not been arraigned or come under court control, the court A must supply the accused with counsel, B may refuse to issue a warrant of arrest based thereon until the court has satisfied itself by inquiry or examination of witnesses that there is reasonable cause to believe defendant committed an offense charged. C may refuse to issue a warrant of arrest based thereon until the court has satisfied itself by inquiry or examination of witnesses that there is reasonable cause to believe defendant committed the crime charged only if the accusatory instrument charges a felony. D must issue a warrant of arrest in order that defendant be arraigned on the accusatory instrument. The answer is B, may refuse to issue a warrant of arrest based thereon until the court has satisfied itself by inquiry or examination of witnesses that there is reasonable cause to believe defendant committed an offense charged. So B is the correct answer. Let's see what's on the back here. If not, we'll go straight to CPL. It's incorrect because of its limitation to felony charges. It's incorrect because a summons may be used or the district attorney may be authorized on his request to direct the defendant to appear for arraignment. Let's look at the actual CPL. Hold on. Actual CPL. This phone situation is like really getting on my nerves. Okay, so section 120.20 is warrant of arrest when issuable. Issuable. So 1. When a criminal action has been commenced in local criminal court or youth part of the superior court by filing therewith an accusatory instrument other than a simplified traffic information against the defendant who has not been arraigned upon such accusatory instrument and has not come under the control of the court with respect thereto. A. Such court may, if such accusatory instrument is sufficient on its face, issue a warrant for such defendant's arrest. So basically the court can issue the warrant of arrest. Second option is B. If such accusatory instrument is not sufficient on its face as prescribed in section 100.40, and if the court is satisfied that on the basis of the available facts or evidence, it would be impossible to draw and file an accusatory instrument that is sufficient on its face, the court must dismiss the accusatory instrument. Okay, so you can file the warrant of arrest if it's on its face, it's correct. If it's not on its face correct, as to section 100.40, it can be dismissed. The court must dismiss the accusatory instrument. And then we go to 2. Even this is the reference of the question, because it's 20-2. 2. Even though such accusatory instrument is sufficient on its face, the court may refuse to issue a warrant of arrest based thereon until it has further satisfied itself by inquiry or examination of witnesses that there is reasonable cause to believe that the defendant committed an offense charged. So they're going to look into the witnesses to see, is this legit? Is this something that is feasible, right? Is there reasonable cause to believe that the defendant committed the offense? Upon such inquiry of examination, the court may examine under oath or otherwise any available person whom it believes may possess knowledge concerning the subject matter of the charge. So they're going after the witnesses to see if there's anything to it before they're going to issue the warrant of arrest. Okay, 3, notwithstanding the provisions of subdivision 1, if a summons may be issued in lieu, which means in place of a warrant, so the summons is going to be issued in place of a warrant of arrest, pursuant to section 130.20, and if the court is satisfied that the defendant will respond thereto, it may not issue the warrant of arrest. So they're going to, instead of doing the warrant of arrest, they feel like the defendant will show up if the defendant gets a summons. So instead of, and in place of the warrant of arrest, they're going to issue the summons to bring them in for arraignment. Okay, upon the request of the district attorney, in lieu of or in place of, in lieu of means in place of a warrant of arrest or summons. So now in place of the warrant of arrest or in place of the summons, the court may instead authorize the district attorney to direct the defendant to appear for arraignment on a designated date if it is satisfied that the defendant will appear, right? So those are the options that are coming up. The options that are coming up is that either the court can issue the warrant of arrest. If at face the warrant of arrest is the accusatory instrument is like bogus, it can be dismissed. Right? Or hold on, I gotta review this. Okay, it may refuse to issue the warrant of arrest like without an inquiry of the witnesses to see like how legit this this charge is. And upon such inquiry and the court may examine under oath and otherwise any available person whom it believes may possess knowledge concerning the subject matter. So they're going to interview the witnesses. Okay. And then the other consideration is instead of the warrant of arrest, they're going to do the summons. They're going to issue the summons. And then the last one is that if they decide not to, in place of issuing a summons or a warrant of arrest, they may just say to the district attorney, hey, you know what? On this date, contact the defendant to show up because they feel like the defendant will so appear. And those are all the options relative to this.